Good afternoon.
You're up.
May it please the court. My name is Ralph Brooks, and I represent the appellant petitioner in this case, Christine Patton. Christine Patton is a residential neighbor of a proposed development for what I would call a mega hotel. This town of Fort Myers Beach City Council approved an exceptional circumstance allowing the hotel to exceed the allowable 84 units to go to 254 units under a section of the code that we argued is unconstitutionally vague. It also vests unbridled discretion in the town council itself. This is found in the order that we'll be talking about and reviewing here from the circuit court on page 474 of the appellate appendix. It's APP 474, paragraph 31. And it ties also, we'll be addressing page 473, paragraph 27. In the first section of the order, the court notes that we argue that the exceptional circumstances does not have a definite standard that would apply to everyone. It's not discernible to a neighbor. It's not discernible to a developer. It is unknown exactly what it takes to achieve an exceptional circumstance. The code itself says that normally you take the amount of multifamily units that could be built, in this case 28, and you have an equivalency factor of 3. So you multiply that by 3 and you achieve 84 units. Utilizing this section of the code, which has no upper bound, no upper limit, except one thing that I'll get to a little bit later, intensity. It says guest units exceeding these equivalency factors may be allowed under exceptional circumstances as described in the comprehensive plan if approved as a deviation through a plan development rezoning. And then it goes on to say, before approving such a deviation, the town council must find that all aspects of the development, parentheses, height, traffic, intensity of use, etc., are compatible with the surrounding area, that the proposal clearly exceeds all standards of Fort Myers Beach, and in no case can the equivalency factor increases exceed the maximum intensities allowed in Fort Myers Beach.
Isn't this an argument about the correctness of the underlying ruling as opposed to whether due process was furnished, was given, and the correct law applied? I mean, aren't we on a different standard here on the surface proceeding, correct?
And this is a certiorari proceeding. In the case of Save Brickell Avenue, the unconstitutionality of the underlying ordinance that allowed them to approve a development project because it vests unbridled discretion was held to be unconstitutional and void. Therefore, the approval of the development itself was stricken and reversed and quashed in Save Brickell Avenue case. It's very important that the codes itself have some definitive standards. They are there as explained in the OmniPoint case, so that persons are able to determine their rights and duties. Decisions are not left to arbitrary and capricious administrative determinations, that all applicants will be created equally, and that meaningful judicial review is available. So everyone is left to wonder how much is required or what is required to show an exceptional circumstance. That's the first test. It's not shown or defined any further than that. Even looking to a common dictionary definition of exceptional circumstance, that could be almost anything. Therefore, you can't approve going from 84 units all the way up to 254 in this case, of almost 400% increase, simply by saying there's exceptional circumstances. You can now deviate from the maximum allowed hotel units in the code. The code, if it does have any standard, it says if you do grant exceptional circumstances, you can't exceed the maximum intensities. Yet another deviation was granted to exceed the maximum intensity. That's measured the floor area ratio in the planning world. They look at intensity as floor area ratio. And they added tens of thousands of additional square feet by going from 3 stories, which was the maximum height, with the deviation to 4 stories, they added 113 additional hotel rooms. So not only have they exceeded the height limit, but they have exceeded the limitation that's on intensity. Now, the interveners, they say, well, we're allowed to give deviations in planned unit developments, but under the section for giving deviations for density to allow these exceptional circumstances to apply, you cannot exceed the maximum intensities that are there. That's to put some upper cap on how much additional density you're awarding here in hotel rooms. That was exceeded in this case. In fact, they granted a deviation to the intensity and to the height and to the density. Now, the circuit court erred when it found that the height and intensity were interwoven with the exceptional circumstances for the increase in number of guest rooms. That's prohibited by the code section, 1803A2. It says you cannot exceed the maximum intensity. So if we are going to analyze with precision the precise words in the town code and the plain meaning of the language in the code, they could not have exceeded the intensity, yet they did. Now, it's important that we look back at the exceptional circumstances. That's not defined whatsoever. On pages 4 and 5 of our reply brief, we cite to a number of cases, North Bay Village versus Blackwell, which says that a city council cannot delegate itself an arbitrary and unfettered authority to decide how big a structure should be built or where it's located without setting up reasonable standards which would be applicable alike to all property owners. In Miami versus Say Brickell, again, if definite standards are not included, then the ordinance itself is an invalid delegation of power to itself, and they cannot use that to approve things. This is again found in St. Petersburg in the Second District Court of Appeals, St. Petersburg versus Austin. An ordinance must contain standards to guide the commission and whether to grant or deny an approval. In that case, it was a special exception. In Machado versus Musgrove, it said that you must invalidate special use permits where they did not have a sufficient standard upon which the applications could be considered. There are a myriad of properties, a myriad of potential circumstances, what constitutes exceptional. The city has made up some things in the ordinance, but they're not found in the code.
I just want to interrupt you for a minute because I think, you know, Judge Northcutt maybe tried to steer you in the right direction, but it would help me if you would frame. I understand that you think there are a lot of problems with what happened, but we have a very limited scope of review, and it would really help me understand your argument better if you would tie these things with what we must look at, which is how did the circuit court deprive your client of due process, and what law did it fail to apply that it should have? So you're reciting a lot of things that you believe are problematic, but you're not linking it to those two things. And the linkage is not readily apparent to me. So if you could help me by doing that, I would appreciate it.
Yes, thank you, Your Honor. In the Florida Supreme Court, in the case Allstate versus Clacamanos, held that the Second District Court had previously been too narrow in reviewing circuit courts in certiorari. And it said that after reviewing a number of cases, we conclude the Second District has too narrowly interpreted what constitutes clearly established law for the purposes of certiorari. These cases illustrate that clearly established law can derive from a variety of sources, of legal sources, including—
So what clearly, and I understand that. Yeah. So what clearly established law did the circuit court fail to apply? I believe in your brief, you said it failed to apply was it the zoning code?
Yes. In paragraph 31 of the circuit court order, the circuit court judge described, I think she made a mistake. She said respondent argued. I think she meant intervener argued. but it says respondent argued that neither the LDC nor the comprehensive plan define exceptional circumstances, and that it is left to the discretion of the town to decide on the value of the offered public benefit or exceptional circumstances determined on a case-by-case basis. Now, clearly established law under Clackamas includes well-established recent controlling case law. So those are the cases that I was walking you through on page 4 and 5. It also includes the code itself as a statute or a code or a regulation. Clearly established law in this case requires under 180302, if you are going to find exceptional circumstances, which we think is unbridled discretion, even if you go that far and you apply it, you can never exceed the maximum intensity that's allowed in the town. And that's measured in floor area ratio, and they got a deviation to go from 1.0, 1.4, all the way up to 1.55. So it's a violations of the town code is clearly established law. Violations of this unbridled discretion.
Let me just stop you. I want to make sure I understand. So you're saying even if you look at the provision that allows a deviation for exceptional circumstances and you find exceptional circumstances, the town code doesn't let you go beyond a certain limit, even with exceptional circumstances, and the trial court did not look at that code provision?
In answer to the first part of the question, yes, the town code says that you, in 34-1803-2C, in no case can equivalency factor increase in the density exceed the maximum intensity allowed. And in this case, it did.
Okay. So that's notwithstanding exceptional circumstances.
Yes, if first they have to find exceptional circumstances, and then when they do, then they have to do the following things. They can never go beyond that. And that's because
And are you saying the trial court did not consider that provision?
The trial court rejected my argument in paragraph 31, but I believe it's a valid argument.
Okay.
And then also in paragraph 27, the circuit court erred when it said that height and intensity were interwoven with the exceptional circumstances to increase the number of guest rooms. Because again, the code says in no case shall intensity, FAR, be exceeded as a result of the increase in the hotel room equivalency ratios. So I think she missed, the circuit judge missed that in paragraph 27. We did not have the opportunity to do oral argument. It was a one judge review. The judge, after she denied the oral argument, did send an order asking for supplemental briefing and memorandum on the town code. And we included this in the supplemental memorandum. It was also in our petition and in our reply. I think this case is very important as Judge Pariente pointed out, that in light of the far-reaching impact of zoning decisions, it's important that we look at these violations of code. There is a case, City of Miami versus Say Brickell Avenue, that challenged these planned development ordinances that give the developer an opportunity to avoid zoning laws for height, intensity, number of units. The PAD or PD in this case has deviations. These deviations are granted in the ordinance, but they don't have the same type of criteria like undue hardship and those things that are required for a variance. Yet they allow you to deviate or vary from an ordinance in a PAD. But in this case, to grant additional height or additional density beyond what's allowed, the 84 units, all the way up to 254 units, by simply saying, well, there's exceptional circumstances, and then going outside the ordinance to talk about, well, we're getting a view shed. The developer is offering us property that we can now own and use for a parking lot. That the developer is going to provide employee parking off the island, outside the town, across the bridge in unincorporated Lee County. All these things they looked at and they claim now that that is exceptional circumstances. But none of those are listed in the code. Those are made up on an ad hoc case-by-case basis, and that invites the opportunity for arbitrary and capricious decision-making like what happened in this case. It affects my client and her rights because she has a right to rely on the legitimate and protectable interest in the character of her neighborhood, which is limited to this equivalency rate of 3.0. It's limited. In no case can they exceed the maximum intensity, yet they did. In this case, simply because the applicant had the political power to work the will with the town council that they thought they were getting enough benefits, that this was a exceptional circumstance, so they would in exchange award additional density. 400% in additional density. It's not 1 or 2 units, and it's not a minor ambiguity, which is what they said, we're resolving minor ambiguities, but this is a huge big deal. It will be the biggest hotel. It encompasses both sides of the street. It has the beach side, it has the town side, it has a walkover across Estero Boulevard, which is like A1A on the East Coast, or Gulf of Mexico Drive in the Pinellas, Hillsborough area. It's a massive undertaking that far exceeds what was allowed. And
Brooke,
we're asking,
you did not mention whether you wanted to reserve rebuttal time, but you're down to 5 minutes. So
I'll reserve the rest of my time for rebuttal. Thank you.
great. Okay, you guys, have you discussed how you're going to handle your time?
Yes, Your Honor. May it please the court, I'm Russell Schropp, and I'm here today representing the TPI FMB entities who are co-respondents in this matter with the town of Fort Myers Beach. The town and TPI have agreed to split our time equally, 10 minutes.
Okay, that's good. All right.
And I will go first if that's acceptable with the court.
Yeah.
If I may begin simply by touching very quickly on 2 things that I'd like the court to keep in mind when listening to the arguments that are presented today. The first is that we are here on a second-tier certiorari review of the town's zoning decision. And as I'm sure the court is aware, second-tier review has been called exceedingly narrow in scope. Second-tier review is limited to 2 issues, essentially, whether the lower court afforded procedural due process to the parties, and also whether the lower court applied the correct law.
Well, let me ask you this about the standard. Okay, so it's whether they applied the correct law. It seems like one of the provisions of the law that the petitioner has contended were not applied is one that is binary in one manner of understanding it. Either you can, a city can or cannot increase intensity with the finding of exceptional circumstances that warrant increase in density. So let's say the court looked straight at it, heard argument about it, but still allowed the developers to increase intensity. So we could say, well, the trial court heard the law, he applied the law, but what if we find that he just ignored what is a binary choice between increase in intensity or no increase in intensity? Could that meet the standard of not applying the right law? And I'd also like to know whether you agree with with that characterization of how the law was applied.
How the law was applied, Your Honor? Was that the last question? Yes.
Yes.
Okay. So in terms of applying the law, the case law is clear that an incorrect application of the correct law is not an error that can be taken up on certiorari review. But the question here is whether the correct law was applied. And in this case, the correct law was applied. The criteria are specified in the code for the granting of deviations as part of the plan development process. The town first went through all of the criteria that are specified in the code, and then the lower court below reviewed the town's findings and found that, yes, in fact, all of the criteria that are specified in the code were met by the applicant here. We are in a plan development process. And as part of that plan development process, the code, the applicable code, which is the applicable law in this case, allows the developer to request deviations from certain development parameters that are specified in the code. But they can only be granted if certain criteria are met and if the public health, safety, and welfare is found to be maintained by the town council. Those criteria were applied, they are specified in the code, and they were applied by first the town and then the court to uphold the deviations and grant the deviations. So in fact, what we have here,
my question, and I'll interrupt you. So I can have an answer to my question so other judges can ask questions. If whether a law is applied is a binary proposition, meaning there shall not ever be increase in intensity, and the trial court allowed an increase in intensity, is it not plausible to infer from that the trial court did not apply a provision of a law that ought to have been applied?
If that was in fact the case, that the law said that you could not increase intensity, and then the town.
Well, that's what I want to hear your opinion about.
And that, I think, would be more in keeping with what the petitioner is arguing. But that's not the case that we have here, Your Honor, with all due respect. The petitioner cited to section 34-1803 and the criteria that are contained in there for exceptional circumstances. And even that law provides that you can grant deviations from hotel density, which was what was granted here under exceptional circumstances. But the code also requires that all other aspects of the development, height, traffic, intensity of use, are compatible with the surrounding areas. So you've got that limitation. Then it says the proposal must also clearly exceed the requirements of the Fort Myers Beach Comprehensive Plan. So you've got that limitation here that would also apply. And finally, the point that Mr. Brooks made with regard to the provision that says, in no case can the equivalency factor increases exceed the maximum intensities, and he stopped there. The rest of the sentence reads, allowed by the Fort Myers Beach Comprehensive Plan. Mr. Brooks is asserting that the limitation on floor area ratio contained in the Land Development Code, which is 1.4, should not be exceeded. But that's not what this requirement says. It says that the limitation, the maximum intensities allowed by the Fort Myers Beach Comprehensive Plan can't be exceeded. And those in the record are 2.5 FAR, not 1.4, as Mr. Brooks asserts. So the approved FAR of 1.55 under the deviation still comports with the requirement in the code that the intensities allowed by the Fort Myers Beach Comprehensive Plan aren't exceeded. So I don't think we have that binary situation here where the code says clearly you can't approve anything that's more intense than X, and the town went ahead and approved more than X.
Thank you.
Thank you. So basically, with regard to whether the lower court applied the correct law, this issue really, in our opinion, is really straightforward. And this is the first prong of the second tier review. The parties all agree what the correct law is. It's the town of Fort Myers Beach Land Development Code. The applicable law includes the process for requesting deviations and includes the criteria in the code for requesting deviations. The lower court reviewed the evidence from the town's quasi-judicial hearings, found that the town granted the deviations based upon competent and substantial evidence in accordance with the code's criteria. Once the lower court did that, its review was essentially over under first tier review. The lower court was not permitted to reweigh the evidence that was presented to the town.
On second tier, we are not permitted to examine the evidence to see if the circuit court was correct in that conclusion, correct?
Yes, sir, that is correct. And the third prong of first tier review essentially disappears on second tier review. Now, petitioner is asserting that one of the findings required by the code for hotel room density deviations, that being the exceptional circumstances standard, is unconstitutionally vague. But case law is clear, Your Honor, that the constitutionality of an ordinance can't be challenged through a petition for certiorari.
In the event, what's challenged here in this proceeding is not the code, correct? It's the ordinance that was adopted for this development.
That's correct.
So if there was an unconstitutional provision in the code, there would have to be really a declaratory action to have that declared in a lawsuit, correct?
Yes, Your Honor. That's essentially the holdings of the Nostimo case and the City National Bank case from the Second District Court of Appeal, as well as the OmniPoint Supreme Court case that basically says, if you're going to challenge the constitutionality of the underlying code, you've got to bring it in an original action brought in circuit court. Now, as to the whether the lower court afforded procedural due process to petitioner here, which is the first prong of the test. I think it's important to recognize that the argument the petitioner makes is really that the court didn't make adequate findings and merely blessed the town's ordinance after a cursory review. But this is certainly not supported by a review of the order. In this regard, I think it's important to look at the limited scope of what petitioner actually asked the lower court to opine on and rule on below. There were only 3 issues raised. The first was that the time allotted petitioner to speak to the city council or town council was inadequate. And the court dealt with that issue in paragraphs 20 through 22 and made specific findings of fact and conclusions of law. The second argument raised was that the deviations exceeded the height, density, and floor area ratio permitted under the code. And the court said in paragraphs 23 through 29, essentially, that yes, these parameters that are allowed under the code are exceeded, but they were allowed to be exceeded because deviations were requested and properly granted by the town council. And finally, below, the petitioner made an argument regarding a 1-sentence argument that there was not competent substantial evidence, and the court addressed that in paragraph 30 of the order. That's it. That's really all that was raised before the lower court below. The lower court did review each of these arguments thoroughly and addressed each one separately in the order denying the petition. As to the other arguments raised regarding procedural due process, TPI will simply rely on its response filed with this court, but we're certainly available to answer any questions on procedural due process or on the application of the correct law as done by the lower court in this case.
Mr. Schropp, you're at your 10-minute mark.
Thank you. Good timing.
Yeah, perfect. So it's Mr. Heron's turn.
Thank you. May it please the court, John R. Heron Jr. with the firm Fox Rothschild on behalf of the appellee town of Fort Myers Beach. I'd like to add some additional comments to my co-counsel's very well-reasoned argument and comment upon the argument of Mr. Brooks with respect to the alleged errors that occurred at the lower court level and at the town council level. As Mr. Schropp indicated, the proper remedy to challenge the unconstitutionally or the vagueness of these alleged vagueness of these regulations would have and should have been through a declaratory judgment action, not through a cert proceeding. To the extent that it is the town's position that to the extent that Mr. Brooks and Ms. Patton attempt to assert that the trial court deprived his client of due process by not setting forth sufficient documentation of the council's decision, and the trial court's decision in turn belies the entire record. Set forth in our joint reply brief, this hearing spanned more than 3 days, 22 hours of testimony, multiple reports prepared by various experts engaged by the town, and ultimately the record before that was before the circuit court sitting in its appellate capacity exceeded almost 1,000 pages. In that regard, the case that Mr. Brooks relies so heavily upon, the Dassault case, very clearly says that the court sitting in its appellate capacity at the circuit court level has to review that entire record. And there's no evidence or no arguments have been made that the court didn't do that. In fact, the trial court's order is relatively lengthy, well documented, and very thorough. To take Mr. Brooks' argument to its logical extreme, trial court orders on petitions for writ of cert, as well as the ordinances that adopt rezonings of this nature, would rival appellate briefs in nature, in their size and length. That frankly is not required by the Dassault opinion, which coincidentally Mr. Brooks is relying primarily upon the concurring opinion, not that of the majority court. With regard to the issue of deviations, I think that Mr. Schropp adequately identified that there are numerous criteria that the town council had to follow before granting those deviations. And they are set forth with specificity in the code, which we have cited to in our reply brief. To that extent, section 34-217 of the town code very specifically says that after the adoption of the master concept plan in a PD rezoning, the conditions and auxiliary documentation that govern it and any all development and subsequent use of land, water, and structures within the plan development shall be in compliance with the following in order of precedence: Fort Myers Comprehensive Plan, the subdivision of the land development, this subdivision land development code, the master concept plan, any applicable town development regulations in force, and general provisions of this chapter, unless otherwise accepted by an approved schedule of deviations. And that's exactly what took place here. The town council had before it, as part of the application, a series of deviations, and that is a requirement of the application process. In due course and through the various public hearings that took place, those deviations and the criteria that govern those deviations were in fact considered by initially town staff and generating their recommendation to the local planning agency, the local planning agency at that public hearing process, and ultimately before the town council when it held 2 separate public hearings as required by state law to adopt the rezoning ordinances. Last but not least, in that same section of the code, it's the town code, the land development code, says that development pursuant to the master concept plan is subject to all development regulations established to protect health, safety, and welfare enforced at the time of submission of the application for a development order, except where deviations have been formally granted in accordance with section 34-932B of this chapter. Again, that is exactly what took place here. Mr. Brooks' reliance on the North Bay case for the proposition that there were no criteria, and when that takes place or when that happens, a court is bound to reverse the lower court on the grounds that it didn't observe the essential requirements of the law, is inapplicable here. The North Bay case, if you read it, Your Honors, it very clearly states that the facts in that case are that no standards existed. It was purely discretionary as to whether or not the North Bay Council approved gas stations and where they could go, and it was purely an ad hoc decision. That is not the case here. We don't have ad hoc criteria that gets applied on a case-by-case basis. There's very specific criteria, and frankly, from my experiences in the town, deviations are requested routinely when plan development applications are submitted to the town council. And so the proposition that the town council did not have specific criteria to follow and to guide its decision-making process is one, not supported by the code, which is the applicable law, and two, by the record itself that was before the circuit court. I'd also point out that in our reply brief, and this, as Mr. Shaw properly pointed out, a number of these arguments that are raised by the appellant were not raised at the circuit court level in the original cert petition, and therefore are outside the record and not appropriate for review by this court. I'll rely upon the cases cited within our reply brief for that proposition. And in some, we believe that a very record was developed. Very specific criteria were followed, and very specific findings were set forth in the ordinance granting the rezoning, and certainly the circuit court order and reviewing that. To suggest that somehow due process was denied here because there weren't sufficient findings of fact, again, is inconsistent with the record and the documents before you. And more importantly, I believe it's an attempt by the appellants to attack the decision of the circuit court as to the competent substantial criteria through the back door of saying, well, they didn't observe the essential requirements law, or alternatively, didn't grant us due process because they didn't set sufficient facts. I'm available to answer any questions the panel may have, and we ask that you uphold the decision of the circuit court in its entirety.
Thank you, Mr. Herron. Okay, Mr. Brooks, you've got 5 for rebuttal.
Yes, Your Honor. In the city of Miami versus Save Brickell Avenue, they addressed the unconstitutionality of the underlying ordinance in certiorari. It has happened before. It seems that it would make us go back to square one, refile a declaratory judgment action. While we're here now, certainly clear principles of law include the Constitution. I think in this particular circumstance, like in Save Brickell Avenue, in interest of judicial economy and of the parties, this has been argued. It's been in the briefs. It's in the order in paragraph 31. I think that this court could help us all by deciding that issue now, whether or not exceptional circumstances vest unbridled discretion. And I know that normally you don't do that, but it has happened before. And I would ask that, and otherwise we have to go back and start all over again. I think it can be done. There is a case that says under your second tier review, and I hate to use this analogy, but the court itself said it in Auerbach. They said that Omnipoint, Dania, Valiant, your second tier review does not render the courts of appeal legal potted plants, powerless to review and correct manifest errors of law and policy. And I think that's what's happened in this case. We have a case where the development clearly exceeds the number of hotel rooms from 84 to 254. It's a gross increase, exceedance, and it's all based on exceptional circumstance, which is not further defined. And for that
Excuse
reason,
me, did you say paragraph 27
paragraph
of the order
paragraph
addresses
30
the constitutionality of this?
I meant 31. I'm sorry. 31 is the constitutionality, and 27 is the combining partially approval of all the deviations together. The deviation for intensity, the only thing they are allowed a deviation for exceptional circumstances is for density. There's no exceptional circumstance criteria to
I don't see what
intensity.
you're arguing, and I don't recall seeing in your petition to the circuit court that you raised the constitutionality. Like the circuit court did not make a determination on that I can see, nor did you ask them to.
In paragraph 31, she talks about my argument. I can go back to the petition.
I'm
very
looking at
quickly.
paragraph 31, but I don't.
If you
see
give me
what
just a
your-
minute, Your Honor.
And your petition didn't ask for that.
My petition did describe all of the,
Your request for relief was that you wanted an order quashing the decision below for failure to afford procedural due process and failure to comply with the essential requirements of law. That's what you asked for.
if you look at my original petition, it's on page 30 and page 31. We talk about exceptional circumstances. By not specifying objective criteria for determining exceptional circumstances, the town council standard for ruling on rezoning applications is inherently subjective and vague. University Books, Lady J. Lingerie. The failure to define what constitute exceptional circumstances results in the town council making arbitrary and largely unchecked decisions to suit its wishes rather than the public's need. The town council has used, expanded, and abused the phrase exceptional circumstances and applied it at a whim. The town engaged in this inherently subjective and unconstitutional practice when it approved the ordinance. In the ordinance, town council cites to exceptional circumstances as its basis for
Did you
deviating
ask
from the
the
Land
circuit
Development Code.
court? Did you ask the circuit court to find that the ordinance was invalid?
On the bottom of page 3, the standard that changes for each rezoning applicant is inherently subjective, manifestly unjust, and unconstitutional. And then on the next page, I go to OmniPoint, explain why it's unconstitutional. This court is required to remedy that, and I cite to Miami-Dade versus OmniPoint.
Okay.
The issue about the intensity,
Go ahead, Judge Atkins.
Judge Northcutt?
Go ahead.
The issue about intensity, I was wondering if you wanted to respond to opposing counsel's argument that the intensity did not exceed the plan, that the standard that you referred to was the lower intensity level prescribed by the code, whereas the exceptional circumstances provision requires that the intensity not exceed the plan.
The comprehensive plan is implemented by the land development regulations. In this area, it's more limited than the 2.5. It is, in fact, it was 1.0 and 1.44, and they raised it up to 1.55, increasing the square footage of the site, thousands of square feet.
Okay.
So you oh, sorry, Judge.
Trying to call time, but I'll let you finish, Judge Atkins.
You contend that opposing counsel was incorrect, that it actually intensity exceeded the plan.
I will have to go back and see what's in that plan that he cited, the 2.5. I was looking primarily at the land development code. Comprehensive plan challenges have to be brought under 163.3215.
Yeah, but the vision says plan. Okay, thanks, Judge
The
Northcutt.
point was is that the limitation on exceptional circumstances referred to the limit imposed by the plan as opposed to the code. Somebody nod your head if I'm correct.
Well, the first one, A, says all aspects of the development, height, traffic, intensity of use are compatible with the surrounding area.
It's not a
And it does
flaw.
go to the
It's not
plan.
a flaw that the variation offered imposed by the exceptional circumstance exceeded the code. It did not exceed the plan. That's what their argument is.
That's their argument, and we believe that they did exceed it, and they can't use exceptional circumstances to increase that intensity. It's only can be used for